Good evening, everyone. The March 17th, 2026 Arlington County Board of Zoning Appeals hearing is now in session. Is it really the 18th? Sorry, 18th. Thank you. I am Richard Kaplan, I guess partially chair of the Board of Zoning Appeals at the moment. The board is made up of 5 citizens appointed by the Circuit Court. Tonight, in addition to myself, we have members Inta Malice, Judy Freshman, Carol McCoskry is joining us remotely, and Alex Kumana. Also present is the professional staff, including Lindsay Klein, BZA Coordinator, Megan Ryan, BZA Associate Planner, Brett Goldberg, BZA Associate Planner. Sorry, you were hiding behind Inta. And I assume online is Stephen Rissy, Zoning Prim Supervisor. To avoid disruptions, we ask that you please place your mobile devices in silent mode. Before we begin tonight's hearing, I will discuss this board's powers and the procedures for tonight's hearing. The board's powers are prescribed in the Code of Virginia and are set forth in further detail in the county's zoning ordinance adopted by the county board. The Board of Zoning Appeals does not have the power to rezone property or to amend the regulations set forth in the ordinance. That authority rests solely with the county board. This board does have the authority to do 3 things. First, the BZA can approve use permits that allow modifications of placement requirements for structures on 1- and 2-family lots where there is no option in the zoning ordinance to allow such modifications. In order to approve a use permit, the Arlington zoning ordinance requires that this board find that the proposal will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not be in conflict with the purposes of the master plan and land use and zoning related policies of the county. In making these findings, the BZA shall consider whether the modification will promote compatibility of the development with the surrounding neighborhood because the structure's overall size, footprint, and placement are similar to those of the structures on the property surrounding the lot in question, and whether the modification will help preserve natural landform, historical features, and/or significant trees and foliage. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary and in the public interest, including but not limited to the duration of that use permit. Second, the BZA can grant variances from the specific requirements of the zoning ordinance. When granting variances, the burden of proof is on the applicant to prove by a preponderance of the evidence that the strict application of the ordinance would unreasonably restrict the utilization of the property, and the need for a variance would not be shared generally by other properties, and such variance is not contrary to the purposes of the ordinance. Or that the strict application of the ordinance would unreasonably restrict the utilization of the property, or that granting the variance would alleviate a hardship due to a physical condition relating to the property or improvements thereon at the time of the effective date of the ordinance, or alleviate a hardship by granting a reasonable modification to a property or improvement thereon requested by or on behalf of a person with a disability. In all variance cases, the property for which the variance is being requested must have been acquired in good faith, and any hardship was not created by the applicant. That the variance granted will not be a substantial detriment to adjacent property and nearby properties in the proximity of the geographic area. That the condition or situation of the property concerned is not so general or reoccurring in nature as to make reasonably practicable the adoption of an amendment to the ordinance. That the granting of the variance will not result in a use that is not otherwise permitted on the property or change in zoning classification of the property, and that the relief or remedy obtained through the variance is not available through a special exception process as provided for under the zoning or subdivision ordinance. Third, the BZA shall hear and decide appeals of the zoning administrator or from any order, requirement, decision, or determination made by any other administrative officer in the administration of enforcement of Title 15.2, Article 7 of the Code of Virginia. Now on to tonight's hybrid hearing. For those who are participating in person, on the front of the table, you will find a QR code linking to a copy of the application package, including the staff report for each case before us this evening. For those participating virtually, a copy of each application package can be found on the Arlington County BZA website. There is also a link in the chat for the application packages. I recommend that if you have not yet seen that report for your case, that you review that report before your case is called. If you are attending virtually and lose connectivity, please reconnect with us by phone. If you are attending via Teams, please keep yourself muted and cameras off until called upon. Turn off the sound on any other devices around you to minimize interference. When called upon to speak, please turn on your camera and unmute yourself by clicking on the microphone icon that is located in the meeting command bar. County staff does not have the ability to unmute you. The meeting chat is active for technical support assistance only. The meeting chat should not be used for discussion, public comments, questions about agenda items, or requests for more information. All public comments must be shared verbally or have been previously provided in writing for the record during the assigned public testimony period. This evening, staff will call each case and will provide a brief staff report and recommendation. Next, board members will ask any questions of staff that they may have. Applicant or their representative will be given an opportunity to make comments to support the application or appeal. Next, all speakers for the item will be called. Speakers must fill out a speaker slip, which is online or is available on the table in the front of the room. After we hear from speakers for and against the proposal, the board may permit the applicant a brief opportunity to clarify any points. The board may ask questions of any speakers, but does not permit any cross-examination or direct questioning by others. For tonight's hearing, this board has deemed the following time limits for speakers to be sufficient: 20 minutes for applicants of appeals, 5 minutes for applicants of use permits and variances, 3 minutes for representative of organizations, and 2 minutes for individuals as sufficient. After the board has gathered all the information we need and have discussed the case, we will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Please be respectful of the time allotted. This is a public forum, and tonight's hearing will be recorded and posted on the county's website. All information associated with tonight's hearing, whether spoken or written, is subject to the Freedom of Information Act requirements. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. After your case of interest is heard, you are welcome to stay for the balance of the session or leave at your convenience. Before we call the first case, we have some administrative matters to attend to. Tonight, I have a request from BZA member Carol McCoskey to participate virtually. Virginia law requires that there be an in-person quorum to have a member participate remotely, and as such, I will note for the record that we have an in-person quorum. Ms. McCoskey has requested to participate virtually because she is traveling outside of the jurisdiction. Ms. McCoskey, can you please certify that you can hear us?
I can hear you.
Thank you, and I will certify for those in the room that we can certainly hear you. Second, since we had to cancel our work session for lack of a quorum, we have to elect officers. And technically, I am no longer the current chair because my position has expired last week. And so I would like to ask our, I guess, former vice chair, Ms. Malice, to take over with the running of the chair election, because I don't think I should do that as current chair.
Thank
Or
you.
formerly current chair.
Meeting convener.
Meeting convener, I like that.
Thank you, Mr. Kaplan. Yes, we have to nominate we have to elect two positions, the chair and the vice chair.
We do.
Therefore, I nominate Mr. Kaplan to serve as chair for the coming year.
Is there a second?
Second.
I will call the roll.
Sorry, I took over again.
No, I'll just go around there. Ms. Freshman,
Aye.
Ms. McCroskey,
Aye.
Mr. Kumana,
Aye.
Mr. Kaplan,
And because it's not determinative, I will also vote aye.
and the vice chair votes aye. So the nomination, the result is that Mr. Kaplan has been elected as chair for the coming year.
Thank you, Ms. Malice. We now have to elect a vice chair. Are there any nominations for vice chair?
Mr. Chairman,
Ms. Malice.
I nominate Ms. McCroskey as vice chair for the coming year.
Second.
Is a motion to nominate Ms. McCoskey for vice chair made by Ms. Malice and seconded by Ms. Freshman. And is there any discussion on that? Hearing no and no objection, I will call the roll. Ms. Malice,
Aye.
Ms. Freshman,
Aye.
Ms. McCoskey,
Aye.
Mr. Kumana.
Aye.
Chair votes aye, and we have a new vice chair. Congratulations, Ms. McCoskey.
Thank you.
Second item on our, I guess, administrative agenda is that since we missed our work session, I would like to schedule by unanimous consent our work session for May 20th at 5 p.m. The general feeling of the board was that it would be better to have it, although a long day, have it before our May hearing than to schedule a second date. And I believe we've all spoke about this already. So if I hear no
What
objection,
time did you say?
5 p.m.
Are you serving dinner?
We were just discussing that beforehand. We probably will try and work something out. We have to see if we can make that happen.
Okay.
Motion to pass that by unanimous consent.
No objection.
Hearing no objection, our work session shall be scheduled. And although my memory might be failing me, I think that is it for our items to deal with before hitting the actual agenda, although the chair elections were on the agenda. So can you call the second item on the agenda, please, Ms. Klein?
Yes. Case number V-12084-25-VA-2, carry over and withdrawn. A variance request carried over from the December 18th, 2025 BZA meeting by 1921 South Langley Street LLC, the owner who has requested to withdraw their application that previously sought to permit construction of a new one-family dwelling on a lot with substandard lot width and area for the R2-7 zoning district regarding a new one-family dwelling in the R2-7 zoning district on the premises currently known as 1921 South Langley Street, Green Valley. Staff recommends that the board request, the request has been withdrawn by the applicant and no further action is required by the BZA.
Thank you, Ms. Klein. I assume there were no speakers signed up or late
That's
additions? Okay. Can we go on to the next withdrawal, please?
Case number V-12085-25-VA-1, carry over and withdrawn. A variance request carried over from the December 18th, 2025 BZA meeting by 1921 South Langley Street LLC, the owner who has requested to withdraw their application that previously sought to permit construction of a new one-family dwelling on a lot with substandard lot width and area for the R2-7 zoning district regarding a new one-family dwelling in the R2-7 zoning district on the premises currently known as 1917 South Langley Street, Green Valley. And once again, this request had been withdrawn by the applicant and no further action is required by the BZA.
Thank you, Ms. Klein. Assuming that there are no speakers signed up to speak, can we call the next case?
Yes. Okay. Case number V-12087-25-UP-1. UP-1 carryover, a use permit request carried over from the January 21st, 2026 BZA hearing by Per and Erica Midbow, the owners, to permit a rear setback of 2.5 feet to the eave instead of 10 feet to the eave as required, to permit a side setback of 1.1 feet to the areaway instead of 5 feet to the areaway as required, to permit a street setback of 23.3 feet to the building wall instead of 25 feet to the building wall as required along 6th Street South, and to permit a street setback of 18 feet to the porch column, 17.3 feet to the porch eave instead of 21 feet to the porch column and 19.5 feet to the porch eave as required along 6th Street South regarding a one-story detached accessory building with basement and porch on a corner lot in the R6 zoning district on the premises known as 601 South Taylor Street, Barcroft. And staff recommends that staff does not object to the applicant's request to defer the subject use permit request to the June 2026 BZA hearing. And note there is supplemental material for this case that did come in after the application packet was assembled and printed in the form of one comment form from an adjacent neighbor to the west.
Are there any speakers signed up for this one?
No.
No. Does anyone have any questions for staff? If not, I'm happy to make a motion. I would like to motion that this case number V-12087-25-UP-1 be deferred to our June 2026 hearing agenda. There's a second. Motion made by the chair, seconded by Ms. Malice to defer to the June hearing agenda. Is there any further discussion? I will call the roll. Ms. Malice.
Aye.
Ms. Freshman.
Aye.
Ms. McCoskey.
Aye.
Mr. Kumana.
Aye.
Chair votes aye. Motion for deferral passes 5-0. The next two items on the agenda, I believe, are the two variance cases. I would like to, if there are no objections from my colleagues, call these two cases together. And then when it comes to the motions, we can make two separate motions and address it that way. So let's do that.
Okay.
Thank you.
I will read them one after the other then.
Thank you.
Case number V-12095-25-VA-1, consider the authority of the BZA to hear a variance request by Justin Jarkowski of Elevation Homes LLC, the owner, to construct a one-family dwelling on a lot with a frontage on a public thoroughfare having a width of 24 feet instead of 30 feet as required by the Arlington County Zoning Code Section 1.5 regarding the development of a one-family dwelling in the R6 zoning district on the premises currently known as 2717 First Street South. This is Lot 16 of the Henry L. Holmes Subdivision Number 2 in Penrose. And the sole issue to be addressed at this hearing is the authority of the BZA to hear the variance request. And staff seeks direction from the BZA on whether they possess the statutory authority to hear the request. Note there is supplemental material for this case that came in after the application packet was assembled and printed, which includes 2 comments and maybe more. No, for 2 comments and then additional material submitted by the applicant. And then in addition, case number V-12095-26-VA-2, consider the authority of the BZA to hear a variance request by Justin Jarkowski of Elevation Homes LLC, the owner, to construct a one-family dwelling on a lot with frontage on a public thoroughfare having a width of 24 feet instead of 30 feet as required by the zoning ordinance section 1.5 regarding the development of a one-family dwelling in the R6 zoning district on the premises currently known as 2717 First Street South. This is Lot 17 of the Henry L. Holmes Subdivision Number 2, Penrose. The sole issue to be addressed at this hearing as well is the authority of the BZA to hear the variance request. And once again, staff seeks direction from the BZA on whether they possess the statutory authority to hear the request. And once again, there is supplemental material that's submitted for this case after the application packet was assembled and printed, and that includes information submitted from the applicant. That includes staff reports and minutes from 2015, sections of the Virginia Administrative Code, historic sections of the zoning ordinance, and additional materials that, upon request, I can enumerate.
Thank you, Ms. Klein. I know for myself, I have questions of staff or the parties, but I have a feeling my questions will be answered from the presentation of the parties. So do any of my colleagues have additional questions that they want to hear before we hear from the parties?
Mr.
Ms.
Hamlin,
Malice.
I'm fine with, I'll have questions for staff, but I'd like to hear from the applicant.
Is the applicant with us? My sense is that this will probably take longer than the 5 minutes that you were offered.
Not too much longer.
Okay, my thought was to allow you, because there are 2 variances, is to let's do 10 minutes, which is, I think, the fair thing to do, and then we can go from there.
Okay. Let me know when you're ready with the presentation.
I probably just threw the staff off.
TV lights.
We don't.
Can we turn the TV lights off?
We usually don't have them off.
The
on.
TV lights. Please.
We go through whenever they're turned on. We
No,
can never
take your time.
turn them off. It's a thing.
Hard to see you
Ah.
when the light is in there. Okay, all right, thanks.
We've done this before, and we cannot figure out how to turn them off when they're on. So,
Okay.
go ahead. I'm sorry. Can you? I missed your name.
Sure. Andrew Gregg
Right.
with Bean, Kinney and Corman representing Elevation Homes. Justin Jarkowski is here. Chair Kaplan, members of the board. I'm here representing the owner of 2717 First Street South. And tonight's question, does this board have the statutory authority to hear a variance from section 1.5? I will demonstrate that the answer should be yes. Next slide. Before I explain why we believe you have authority, let me be clear about what we are not asking. We agree that this board cannot widen a street, alter a public right-of-way, or change the definition of a street. What we are asking is that you vary the zoning consequence imposed by section 1.5, which is a rule that tells a property owner where a building can and cannot be located. Next slide. This is the core of the issue, and it can be resolved directly from the text. On the right is section 1.5. Every building hereafter erected shall be located. That is a fixed placement language. It dictates the physical prerequisite for where a structure may be placed. On the left is the state statute's definition of a variance. It expressly authorizes the board to vary provisions regulating the location of the building or structure. Section 1.5 uses the exact concept protected by state code. Next slide. Staff's report characterizes this as a deviation from a public right-of-way requirement, but that is staff's interpretation, not the ordinance's language. This section does not say that streets shall be 30 feet wide. It says that every building shall be located on a lot with qualifying frontage. Staff is focusing on the street itself instead of the zoning consequence for the lot. We're not asking you to fix the street. We are asking for relief from the specific zoning consequence. Staff's own report acknowledges that these lots would otherwise qualify as buildable, but for section 1.5. That concession itself tells you this is a building location restriction. Next slide. Arlington's own records confirm that this is a zoning buildability rule. Zoning administrator determinations from 1990 and 2009 explicitly declared lots unbuildable, banning new construction solely because of this 30-foot frontage rule. In October 2025, the zoning administrator concluded that the subject lots are not buildable because the right-of-way is approximately 24 feet wide and therefore does not satisfy 1.5. That determination isolates the issue. The county itself treated 1.5 as a rule that prevents a building from being located on these lots. This demonstrates section 1.5 is a strict regulation on building placement, which is exactly the type of zoning consequence the board exists to review. Next slide. The board, when this uncommon hardship arises, this board has acted before. In 2015, you considered the same ordinance, the same variance authority, and the same sub 30-foot frontage problem on North Wayne Street. Over staff's recommendation, the board affirmed its jurisdiction and granted the variance. That decision is not binding, but it is persuasive evidence of how this board has previously understood 1.5. The ordinance has not changed, and the current statute still covers the same question. Next slide. Section 1.5 is a static siting rule, not a public works standard. Because it regulates the location of a building, it falls directly under the variance authority granted by Virginia code. The physical dimensions of First Street South will remain exactly 24 feet wide. We are simply asking to address the buildability of lots 16 and 17. And I would emphasize one final point. No functional alternative relief mechanism exists. There's no special exception, no waiver, no use permit, no administrative pathway. Affirming authority today does not automatically grant the variance. It simply acknowledges your jurisdiction, allowing the applicant the opportunity to present evidence of hardship, reasonable use, and neighborhood fit at a full hearing on the merits. So the question tonight is narrow. Does 1.5 regulate the location of a building? Its text says yes, and the county's own determination confirms that it is the sole barrier to buildability here. And there is no functional alternative ordinance-based mechanism for relief. Next slide, please. Chair Kaplan, newly elected Chair Kaplan. Members of the board, to summarize, section 1.5 is a building location rule. The county's own determination confirms it is the sole buildability barrier here. Virginia's variance statutes cover the exact category. This board already affirmed its power to grant section 1.5 relief in 2015. And we respectfully ask you adopt resolution number 2 and affirm your authority to hear this case. If you do, we look forward to presenting the full merits at the April hearing. Thank you.
Thank you. Do my colleagues have questions for the applicant? I I'll start. The 2015 variance that you referenced, are you familiar with the reasons of the recommendation of denial
I believe
in
it's,
that report?
yeah, I believe it is the same rationale that's being applied in this situation, but I believe Ms. Freshman was on the board at that time, and potentially she could shed a little light as to those particular circumstances, but I only am relying on the staff report and the very slim BZA minutes that I could find through the county portal.
Um,
Can I just follow up?
Go
on
ahead.
that?
Yep, go ahead.
So in 2015, it came before the BZA. Staff had no objection to bringing it to the BZA, but they do now. Can someone clarify why there was no objection then and there is now?
I can start and then let anyone else jump in that would like to, but it's our understanding that it is now come to the forefront that the minimum lot or minimum street width requirement is 30 feet. It was maybe not understood or at that time that was the requirement. So this is why this is our current zoning administrator's application of that requirement as issued in the buildability or zoning administrator determination letter that was sent out in October to the applicant property owner. So it was just not something that was seen or known at that time in 2015.
But in 1990, it was known.
So yeah, we can't understand what slipped in 2015, but it wasn't understood to be whoever was in that position in 2015 did not understand or know that regulation.
I'll just say, the three people that voted for it, one of them was Terry Russell, who was the former zoning administrator. So he would have, I'm sure, been aware of that provision. And he voted for it. Okay.
Okay.
Sorry.
So we got a whole bunch of supplemental material, and so I don't know who provided what page of supplemental. So are the pictures at the end of the picture of the block at the end of the supplemental, are those pictures that you provided, or was that from someone else?
Justin, the owner of the property, Elevation Homes, took those pictures.
So I have questions about the pictures. That's why I'm asking. So-
Sure. Yeah. I mean, I submitted those pictures just to have some situational awareness. They weren't submitted to get into substantive discussion on the merits. It was just to have some idea of what these locations were.
Okay. So I just, can you bring up some of those pictures? And so I don't know that I have questions. I just want to put them in front of everyone because it does look like a bunch of those houses are fairly new. Oh, you beat me to it, right? And so I don't know if this is a question for the applicant or for staff, right? But there are more than one house that looks like it was built brand new and not. There are clearly houses that have been expanded over the years, but there's at least 2 or 3 houses on this block that have been 3
In 2020.
in 2020 and after, right? And so
Right.
I guess my question first is does that fall under the same category of someone approved these houses without realizing and this might be more for staff to answer.
I'm happy to answer that question. Yes. So when you're looking at the site from an aerial looking down, there's 2 properties that are directly to it on the left and 2 properties directly to it on the right. The 2 properties on the left were constructed in 2021. At that time, the county did require that they dedicate additional frontage along to create a sufficient public right-of-way easement at the start of their property to create a lot width that is a minimum of 30 feet or not lot width, I'm sorry, street frontage that is a minimum of 30 feet wide. So that's how they were able to construct it over on the left, those 2 lots in 2021. Conversely, there's 2 lots that were constructed in 2020 to the right, and those were both had the same lot width of 16 feet wide. And it does appear that at that time there was something missed or not understood that was then caught later. But at that time, the building permits had been put into effect and it was effectively, the county could not then go back and reopen the issue.
And so on those two houses that dedicated extra easement, is that not in a possibility in this? Is there a reason why that's not being explored, or has that been explored?
That's a question for the applicant.
Has that been explored?
Yeah, and I'll let Justin come up and address that directly. But my understanding is
Thank you, Ms. Klein.
that was floated during the building permit process and was not accepted. But I'll let Justin speak to that.
So in the frontage of those two properties, there is actually a county easement that did dedicate additional space to it.
But not enough to hit the 30 feet.
So it was 24, I believe the easement is 4, but my understanding is they probably did not receive the same easement on the opposite side of the street. So we've sort of given the width that is on the
So
front.
on this property, according to the staff report, and I'm testing my memory, is that the road is 16 feet wide, and there is an 8-foot easement getting us to 24 feet. So we're essentially 6 feet short of what would be required to do this by right. Is that
That is correct,
right?
based on the application submitted to the
Right.
BZA.
please?
Can I say one more thing? I think that, given more time to address that potentially at the merits, if it does make it to the April meeting, I think that would probably be within the scope of that meeting. In terms of the meeting before us today, establishing authority, I think that really it boils down to, the question of whether 1.5 is a building location, building siting, zoning ordinance requirement. And so I would argue that it is, and I think that you should establish the authority in that manner.
Yeah,
Ms. Mellis?
yeah, don't go away, but the question is for staff. So if the applicant was to dedicate additional frontage, this would not be an issue?
If the applicant was to dedicate additional frontage, they would not come before. There's nothing else that we've reviewed in their preliminary application that would require a variance or use permit from what we've seen. So the subject request that they have submitted is for a variance for the street width requirement. But it really depends upon the judgment of the board as to whether they even have that authority to grant that before they can move on to the second part.
My understanding is that the county would have to actually accept that it's not enough that the applicant just says, here, county, here's a 6-foot easement or a 6-foot easement, right? The county actually has to make that agreement.
That is correct. It would be
Right,
a
and that-
discussion with a different.
And I think this is, we're doing this hearing in kind of an unusual fashion,
Yeah.
right? Where we're hearing, whether this board even has the authority to hear that. And I meant to address this actually at the beginning of the hearing, so I'll just say a quick, and so the reason why we're doing that is because there was a request by the county to not have to prepare for both issues if we weren't going to hit the merits. And my feeling was to allow that because it didn't delay your merits hearing, right? No matter what would have happened, your merits hearing would have been next month regardless, right?
Yes.
And so that was kind of my, the decision that I made as chair to do that, right? Ms. Malice,
So you're,
I'm sorry, can I just finish my,
yeah, go ahead.
right? And so my point is that because this is just a jurisdictional issue, where, my view as one of 5 would be I would want to know much more about that at a merits hearing and whether that was a possibility before we get to a merits hearing. But for a hearing on a jurisdictional issue, in my mind, I'm not sure that I want to explore that more. And that's what I wanted to say.
Yeah, I agree. Whether sort of crystallizing that you would suggest that we have some input on whether there's an easement obtained or needed or not. And I'm not even sure that that's a question that we would get involved in. If that's, because I didn't understand that to be part of the variance at all. But, that there was an easement issue until very recently. So I think it is correct to go back to what Mr. Kaplan said and just talk about location.
Ms. McCroskey has a hand up.
Sorry, it took me a minute to unmute. So it seems to me that there's kind of a very, I would drill down to the very technical issue, as I tend to do. And the question here is whether this regulation about you can't build if you don't have a street frontage of 30 feet. The question is that a regulation on size, height, area, bulk, or location of a building or structure? To me, I mean, I guess I understand that the applicant says it's about the location of a building or structure, but to me, this regulation isn't about where the structure is located. It is about whether the lot itself is buildable. And I think the lot is, I mean, I guess that is, what language, but I guess I leave that for the applicant or their attorney to sort of address, because it does seem to me that this isn't the language, area, bulk, location of the building or structure doesn't say on the property, but it seems to me that is essentially what is really implied, because this is talking about this whole lot, no matter where you put a building on it, you can never have a building or structure on it. So I guess I just put that out there for the applicant to address or staff to comment on if they have any input to help us.
If you wouldn't mind, I'd like to answer that.
Please. And then I am going to offer staff as much time as they would like, as this applicant has had a lot as well. So just to, because state law requires us to offer same time.
My understanding, when the BZA and the courts that sometimes review the appeals to the BZA and the BZA decisions, is that you look at the plain language of the zoning ordinance. What does the language say? And in this case, the language I'll go back to is every building hereafter erected shall be located on a lot. So the plain meaning within the language of the zoning ordinance is a building location issue. The street is the consequence. Where the building located is the consequence. And as a result, I would say that what we're really getting at is whether or not a building can be located on a street that is less than 30 feet. The other thing to address is that if you were to find that you had authority to address Ms. Malice's question from earlier, if you were to find that you had authority, we would be able to examine the easement issue, develop potential alternatives, look at different things, and evaluate it on the merits. If you decide that there's no authority here, that means that this property can never have any new construction of any kind. And not only that, some of the other adjacent property, and I'll, when we get to the merits, potentially Justin will have pictures of other properties on the street. There are some dilapidated properties that aren't being cared for that may potentially, benefit from having new construction. And this sort of bottleneck would make something like that very difficult to accomplish. Essentially, by enforcing this, you are, and I believe the historical 1990 and the 2009 zoning determination are pretty explicit in preventing that sort of new construction from happening. So they really did consider this a buildability issue and a location issue. I hope that addresses it. Maybe staff can expand on it as well.
I would just like to clarify that the buildability of the lot was determined in a zoning determination letter issued in October. That's not the focus of the item before us this evening. The item before us this evening is the request, the determination of the BZA to determine whether the request for a reduction in the lot frontage, street frontage width, sorry, it's a mouthful, is within the purview of the Board of the Zoning Appeals. And it is solely at that at this point. There's nothing more to focus on at this time.
Thank you. Do my colleagues have any further
Well,
questions? Ms. Malice?
I do want to just reopen what Ms. Klein just said. We do have authority regarding buildable lots.
I'm just noting that the determination as to whether this lot is buildable or not was made in a separate zoning determination letter that was issued by the zoning administrator in October, and that's not the request submitted under this variance. It is they're asking for an exception to a component of the zoning ordinance.
So since you mentioned the determination letter, it was. Do you need?
I can just add that the zoning determination letter that was issued in October, there is a 30-day window for them to appeal that determination, and the decision was not appealed at that time. And in that context, it would have also come before the Board of Zoning Appeals instead as an appeal.
Sure.
But
So-
that's two totally different contexts though, right? They could agree that the lot is not buildable, but disagree that it is varianceable.
Right. Because, so you mentioned the determination letter. I found that kind of confusing because it was not, there were two different issues in that determination letter, and I couldn't figure out which one was the major one. One was that it had a frontage problem. The other was they were saying you can't put two houses on the same lot. It wasn't clear on which basis the determination was made. For instance, if they hadn't asked for two houses on the site, would it have been successful? That was what was a little unclear because there were two different variables in that letter.
I'm happy to pull up the letter and read the
No,
determination itself.
I read it too, but I was still confused.
Okay.
As to which was determinate. Was the frontage, were they saying you can't build it because of the frontage, or you can't have two houses on this site? So and I don't know if there may not be any answer to it. It may be just I have to read exactly what the words say.
I think probably,
And maybe,
yes.
and maybe the applicant has
It's my understanding
Sure.
that the issue was not the number of houses, it was the lot width itself.
Yes.
The street width itself that created the,
Okay.
It was basically recycling. Sorry, go
I'm
ahead.
sorry, because they did say it would result in an undersized lot, right? That there was only 49 feet of frontage, there was less than 5,000 square feet per lot. And
that's
so-
correct
So,
as well.
but that wasn't the determination.
That was not the determination because those two lots existed in 1950, and we have that provision in the ordinance that allows for the development of substandard size lots, and they were existed at that time.
But, okay.
Is there anything further from my colleagues? Does staff have anything further that they would like to add? Because like I said, the applicant has had plenty of time and I want to make sure that we're not cutting anyone off.
We're happy to answer additional questions as needed throughout the conversation, but at this time.
Thank you. Discussion with the board.
So,
Thank you.
Mr. Chairman,
Ms. Malice.
I tend to read the ordinance in favor of the applicant, but I can understand why there's an argument. But I do think that it is appropriate to come to the BZA with this, if for no other reason that, one of the functions of the BZA is to act as a safety valve for situations where the plain reading of the regulation might result in some kind of an injustice, some kind of an outcome that just doesn't seem quite right. And I'm sort of tending to see it this way, that we are the safety valve. We don't have to be perfect, but because we're hearing cases that shouldn't, we're the safety valve for a lot of different things. And so I tend to see this as a safety valve issue of, we did it back on Wayne Street and without too much objection. And that it's appropriate that it comes here.
Thank you, Ms. Malice. Mr. Kumana, did you?
Thank you, Chair Kaplan. I agree with everything that Ms. Malice said. I think, I'm trying as best I can to focus on the question asked, and to echo what Ms. Malice said. The idea of not being able to build here ever at all for any reason, if there's some kind of natural disaster that would render this house unusable, that seems to me like a real hardship that boards like us are supposed to help remediate. So that's my thoughts on it at the moment. But I'm interested to hear everyone else's thoughts, and I'm open to what you all have to say on this.
Thank you, Mr. Kumana. Any further?
I agree.
Ms. McCosker has a hand up. Thank you.
Yeah, so I agree with my colleagues that this is not an easy question. This is a close question of how one reads this ordinance and the extent to which it applies. I do think that on the safety valve question, so it does seem to me that it's not necessarily, and someone can disagree, but it seems to me it's not a question of could you ever build on these properties? It's a question of will a street as defined in the zoning ordinance be or exist at some point that is going to enable this type of construction. So I get worried when I hear this means you could never build on these properties. And to me, that's not necessarily correct. You can't build on these properties unless circumstances change. Like you get a wider street, for lack of a better word, even though that it would, until it's that wide, it's not really legally a street. And I'm still a little hung up back on sort of my thinking that this frontage requirement is not about where is the building located, but it's about whether this is a lot that can be built upon because it doesn't have adequate frontage. And you could fix the, ordinance. If 24 feet is wide enough, you could fix the ordinance to do that. But I'm just not certain. And to be honest, I'm not certain which way I'm going to vote in a few minutes, but I just am not certain that this is sort of such a dire case that it has to have a safety valve, and that this is a question of location of a building. I don't think it's a location of a building. I think it's on buildability of a lot.
And that's, and I'm going to make more comments after someone makes a motion, but I just will add to Ms. McCosker that this is just a jurisdictional question, not a merits question, right? So there are still a lot of other issues that will come before this board for this actual project to get approved. That's a whole entirely different discussion as opposed to whether this board even has the authority to hear it. And that's the only issue that's before us tonight. Would someone like to make a motion? Mr. Kumana, or did I cut you off?
I was just going to say that I would like to hear it on its merits. I think that enough of the discussion has shown us that there are a lot of different points of view. And I would sort of side with any lot that's was here for this long should be grandfathered and buildable, but I'm always siding with the exceptions in order to have more housing generally. Nevertheless, on the issue of whether or not we should hear it, yes, I believe we should.
Thank you, Ms. Frischman. Would someone like to make a motion?
I'd be happy to make a motion, but I see the resolution. Do I have to read the whole resolution or is there a shortcut? There's usually,
Yeah.
Staff did not provide a recommendation for this meeting,
Okay.
so unfortunately, there is no motion language provided as well.
I thought it was in the staff report.
There are two
motions in the
so
staff.
it's a very long it's resolution. Can I just move resolution number 1 as per the staff report?
And I would just want to say, I think resolution number 1 is to not hear it.
Right,
Yeah.
make sure you move the right one.
Yes,
Right.
thank you. So I move that the BZA adopt resolution number 2 in V-12094-25-VA-1.
Is there a second? I can't hear you.
Are we doing both of them or separately?
I think we're,
Oh, I
Oh,
see.
you want- thank you.
I did it.
Can
for-
we do,
I did it for 12094.
why don't you do it for both?
so both case numbers?
One
Okay.
motion for both?
I have to find the other case number.
Thank you, Ms. Freshman.
Is it consecutive?
Should be.
Okay, 029095. And I further move that the BZA adopt motion, resolution number 2 in case V-12095-25-VA-1.
Is there a second?
Second.
A motion by Ms. Freshman for V-12095 and 12096 for option number 2 for approval.
Is it 96 or 95?
It's 9-4.
I wasn't looking
It's
at it.
not,
I was taking your word for it. Yeah, I mean, well, which was the motion that you made. Ms. Malice, would you like to alter your motion?
9425
To
and
what?
9526.
The wrong numbers.
I have the wrong numbers?
For clarification, it is 94 and 95.
Yeah, it's not 96.
Oh,
That's what I said.
then it was my
Yeah.
mistake.
Yeah.
Okay,
I
apologies.
moved
A-
94
Apologies.
and 95.
Doing a bad job as newly appointed here.
Yeah, you're new at this.
A motion by Ms. Malice for a motion, option, resolution to approval for V-12094 and 12095. Is there any further discussion? So I'll make my comments now. I just wanted to say I generally agree with my basically everything my colleagues have said. But I just wanted to make a quick statement for just in case there's an appeal for the circuit court. And so, I think in fairness, it would just be an injustice for us to deny even a hearing for the variance for these applicants as multiple properties over multiple years have been built on this block. The applicant also presented us with the 2015 Wayne Street variance, which I am well aware that this board is not supposed to take as precedent. However, the county did not make the argument that the BZA in 2015 didn't have the authority to hear the case, right? And so while I'm not using that as any precedence for the granting of a variance for a particular property, I am relying on that for that issue, right? There's been no evidence presented to this board that any other parcel or house on this block has been denied a permit to build on this block under these grounds, as well as the county has admitted that that might have been something overlooked. And so I think it would just be an injustice for this board to not even allow a merits hearing for this variance. If appealed, the circuit court may very well overturn this board's decision. However, I do feel that the applicant has made a thorough presentation on the issue of whether the street width is persuasive, that the street width is persuasive as being a function of location, that this board does have the authority to hear. So given the foregoing, I just think it would be manifestly unfair for this board to even deny a merit hearing. And as I said before, this is not the merit hearing. We're not granting the variance. And I know that there is opposition in the neighborhood to the plan as built, but we will hopefully hear that next month. So with that, is there anything further? Hearing none, I'll call the roll. Ms. Malice.
Excuse me.
Ms.
I'm sorry.
McCoskey. Oh,
I
I'm sorry, I
just-
didn't see your hand.
No, it's fine.
ahead.
I did want to mention, in light of all the discussions, and I think it's a closed question, but I will just say it is my view that calling this a location requirement is the same as calling, I think, so many different zoning requirements that say you can't have a commercial building in this place, a location requirement, and I think that's not. So I just put that out there to explain my thinking.
Thank you, Ms. McCoskey. I will call the roll. Ms. Malice.
Aye.
Ms. Freshman.
Aye.
Ms. McCoskey.
Nay.
Mr. Kumana.
Aye.
Chair votes aye. Motion to approve the jurisdiction argument in this case passes 4-1. We will see you next month. Ms. Klein, can you please call the next case?
Case number V-12096-26-UP-1, a use permit request by Brian Rosen and Kui Wang, the owners, to permit a left side setback of 8.5 feet to the building wall instead of 10 feet to the building wall as required, and to permit a right side setback of 9.8 feet to the porch and building wall instead of 10 feet to the porch and building wall as required, regarding a new 2-story addition and a new 2-story front porch to an existing 1-family detached dwelling in the R5 zoning district on the premises known as 248 North Bryan Street Line Park. Staff recommends that the board adopt the attached proposed resolution denying the use permit request. An alternative resolution with conditions has been provided should the BZA see fit to approve the application as advertised. And note there is supplemental material for this case that came in after the application packet was assembled and printed. And please also note we have additional speakers who have signed up for this item.
I have 4 speakers. Do my colleagues have questions for staff?
I have a question. I just wondered if you can tell me what it is that's being constructed on what looks to be the rear line, but behind the building, which is already something in progress.
There's an accessory dwelling unit that has been approved and issued a building permit for construction in the rear.
Okay.
Anything further for staff?
Just on that point, is that shown on the plat?
Brett, if you could pull up that plat, yes, in the rear, you can
Plat.
see it there.
That is the accessory dwelling unit. Thank you.
Yes.
I too was wondering if that was part of this or not.
Okay.
So
I have a question.
approved by right.
Correct.
Thank you. Ms. McCoskey.
So as I look at this, it seems to me that if this was moved, if the right side setback was increased by 0.2 inches, then the left side setback would be allowable. Is that correct?
Correct, yes.
And could even be 6 inches or half a foot less.
Correct.
Okay, so
Too was wondering the same thing, but this is an existing house. So isn't that not eligible for the other side setback because the existing setback is 9.8?
Staff reviews in addition as the component that we look at when looking at.
Oh,
Yeah.
okay. So if the addition is actually moved, then staff's position would be that the other addition would be compliant. The other side of the addition would be.
Whichever portion that is being, so hypothetically, if they were to construct the second story on the right side, if that was minimum of 10 feet, then the addition on the other side could have a lesser than 10-foot side setback without the need for the use permit.
So could you? So
Oh.
we're only talking about the setback of the addition, on the right.
Stephen has sent me a message and it's all very confusing, but apparently no, because
Which question are you?
the addition of the second story, because they're adding to both sides and the existing house, as you mentioned, is already there. There's no real way, if they were constructing an addition solely upon the rear and that whole addition
Right.
was meeting the setbacks, but because there's a second story above and they're kind of building up within that area,
So back to Miss Freshman's original question is
yes.
that there is no way to adjust the 0.2 inches to not be in front of us. Or am I misunderstanding now?
Somewhat, yeah, yes. I don't want to give you like a 100% yes, because there are opportunities to construct an addition in a different part on the rear.
No, I understand. No,
Yes.
right. No, I'm talking, right.
Okay.
I'm talking, if we look at the front, right, the right side setback is 9.8. If that right side setback on that porch goes to 10.2 of an inch, would we still be here for the left side setback? Based on,
Yes.
yes, okay. That was
Thank-
my understanding before
thank
you, okay.
Yes.
Bec-
Because
Why would we be
No.
here for, why? If,
isn't there still a
Um,
problem in
I mean,
Promise we will get there.
the rear part?
Stephen, if you don't mind, since you have messaged me and have some experience with the code, jumping in here.
Mr. Rissy,
Yes, the way we look at additions like this, Lindsay was correct in the explanation. If it was entirely in the rear, we would look at the addition on its own, left and right setbacks. If they met the requirements, would be fine. In this case, because the addition is wrapping around the left side of the property, we have to look at the proposed left side addition and the existing right side addition. So it would still be problematic because, as you said, there's an existing right side setback of 9.8. If it was not wrapping, if it did not extend around the corner of the existing building, completely different story. And then you can get into all the hypotheticals that you've
Right.
discussed.
thank you.
can,
Miss Malice,
so if the left side setback was increased by 0.2, it would be conforming?
If the left side, because neither side has 10 feet as proposed, there is no allowable 8-foot. So that's the issue that we have here. Neither side
see.
is meeting the 10, so neither side can have 8. And just as a point of clarification, the plat is drawn in feet, so it is 0.2 feet, not 0.2 inches, just.
0.2 feet, so 0.2 feet, yeah, okay.
And can I,
please.
and so, but the 9.8 is what is existing with the house as it stands today. So that's why they can't
Yes.
fix that to 10 feet in order to get their 8 feet on the other side.
Yeah, it's hard because
Okay,
it's an
thank you.
existing and
I got you.
proposed in this
Okay,
case.
thank you. That's helpful. I was missing that.
Can I also just note that because the existing setbacks of the existing structure are 11 feet on the left and 9.8 feet on the right, currently they do conform because they have 11 feet on one side. They can have 8 feet on the other side if they would like.
Good clarification.
We're kind of reversing that,
All right.
right?
Say that again?
Yes. So because right now the current house has an 11-foot setback on the left,
Okay.
they are allowed to have a reduction from that 10-foot requirement on the other side. It's just that one side has to be at least 10. And if one side is at least 10, then the other side can be 8. So right now the existing structure does conform.
But the 11 goes away with the proposal.
Exactly.
So,
Question.
go ahead.
A question for staff. I may not be able to find it right now. Were there letters of support from the neighbors in the area?
Letters were not provided by neighbors for this applicant.
But we have 4 speakers signed up, so I suspect we will hear from neighbors.
Oh, okay. Okay.
But
Um,
yeah, there were
Mr.
no
Goldberg?
neighbors.
Can you bring up the as-is pictures while we either continue discussing or I call up the applicant? Is there any further questions for staff before I call up the applicant? Let's call up the applicant. Are you the applicant? Please.
So
My English is limited.
Can
I'm
you,
going to use very simple.
can you give us your name for the record?
Jojo, Wang Cui.
Thank you.
Okay.
I'm Brian Rosen.
That's the
Would you
husband.
like to talk about the neighborhood outreach issue that you just
Well, I
brought up?
want you, so first I'm going to ask you to, if you want to speak to just your application.
Yeah,
And then
I-
and then I am sure that that will come up as it's probably on multiple of our minds.
Very good.
So I have to describe the situation.
Describe the situation.
Okay, so we have this old house and as I understand, the county rule is the one side you have 10, the other side have 8. But on the right side of the house that we're looking at, we have 9.8, which is 0.2 short of 10. But if we want to make it 10, so on the left side of the house, if you look at the other picture, we have more room, like although it shows that it's 11 on the front, but on the back, actually the house kind of curves in. So we have more room over there to build if we build on that side. But if we want to use this side as the 8, then the other side has to qualify 10. And that's why we're here, because we can't move that brick wall because it's there already, it's existing wall. And so we're asking if we can use that side as the 10, then we can use the other side as the 8, which I understand that total has to be over 18. So we left 8.5 on the other side. Does it make sense?
Right. Yes.
So that's the situation. And because, you know, if for us to build, like she mentioned, if we can use the left side as the 10, use the right side is 8, then we have to build like the second floor, like hang over. How do you call that? Like the house, second floor has to go outside of the first floor and it would be very ugly. And the other option is to demolish the house and build new, which is more costly. And from a time point of view, it's going to be more time, longer time, you know, and more noise. So that's the situation. So we just want the wall on the right side to go straight up, like right now.
Ms. Mellis, did you have a?
Could you explain again the left side and you said something curves in?
Yeah, so the left side, when you
Is
look
it
at
the lot that curves in or the house?
the house on the left side, it shows setback right now is 11, but it actually, only the front part is 11. On the back, the house kind of cut in. So we have about like 13 and a
Oh,
half.
I see.
Yeah.
There's a bigger setback in the
That's right,
back of
that's
the
right.
house. than the
So we
front of
have
the
more
house.
room to build on that side. Does it make sense? So if we
I
make,
understand what you're saying.
yeah, if we make that side 8 foot, so we have more room, like, you know, to get it larger sized.
Thank you.
Okay.
Did,
Oh, they can address the.
yeah, did
neighborhood.
why don't you address, before you get the question, why don't you address your, you have significant neighborhood
Yes.
opposition.
We
So
did.
So we will hear from your neighbors shortly, but do you want to address any of their comments or outreach?
Do I hand it to you?
So we
You can give it
contacted,
to Mr. Goldberg?
so we contacted all of the addresses that were provided to us by staff, and we've contacted each and every one of them. We received 2 letters.
When you said you contacted, did you speak to them or did you leave a letter on their door? How did, describe your contact?
Both, for one, we spoke to them in person, and for the others, email,
Are these,
text message combination,
And did you have conversations back and forth?
conversation back and forth.
Okay.
We received a third of those addresses provided positive support.
Do we have that?
I give it to you.
You have, okay, that's what you gave. Okay, thank you.
They don't have addresses.
I write it on top.
Right on top is the address. One is on Washington Street. And that one is Barton Street. Yeah. You
Could
have
you
it here.
check all of them?
This,
Mhm.
This one is 255.
Ms. Klein? I'm sorry, one second. I just want to ask you a question because it might create work for you. The two neighboring property, 252 and 244, do we know if they were built by right? Is that something you can easily figure out?
I'll look
Or
into that. Yes,
if it's not easy, don't bother.
I'll go look and see.
Okay, my colleague thinks it's also important. Thank you.
So to be
Go
more
ahead.
specific, 246 Barton Street replied that they support our efforts.
Barton Street is which street?
North Barton?
North
Street,
Barton, is
Bryan.
that Bryan Street?
Barton, oh,
246 North Barton Street is right across the street from us.
oh, I see, it faces.
Further away.
It has
Right
front,
there.
it has frontage.
Oh,
back.
okay.
Okay.
Oh, they have, their address is on the other side.
Yeah,
Thank you.
And 2539 Washington Boulevard is behind us, so to speak.
25 what?
2539 Washington Boulevard, which is in my backyard essentially.
That's 2.
And we received no other,
Two,
Um,
255.
I suspect the rest are here.
That's Amanda.
I'm sure they are. There's quite a lot of personal animus.
Well, we're gonna try and avoid that and, but we're-
244.
I hope you do.
we're gonna hear from, what they have to say. Ms.
Can
Klein.
you clarify your addresses in question? So you asked for 252 North Bryan
The
Street?
adjacent neighbors, on the
Oh,
left
on
and
the
the
other
right.
side.
Yeah,
Okay.
on both sides, the right and the left.
Yes, thank you.
Anything further for the applicant? Please, Mr. Kamano.
Yes.
Let's hear from the speakers, and then if we have questions, we'll have you come back.
Please.
Can I get that speaker list? Can you bring up the speaker list? Mr. Keneally. Thanks for coming tonight.
Good evening. Thank you. Thank you for having me. Good evening, everybody. My comments revolve around the clarity and overall intent of the modifications and expansion of the property.
I'm sorry, Mr. Mr. Keneally, can you tell us where you live?
Oh, I'm sorry.
Assuming it's relevant.
I'll start over again. Good evening. My name is Sean Keneally. I live at 256 North Bryan Street.
So you are the neighbor, the adjacent neighbor.
I am two neighbors
Two neighbors.
to the right
Okay.
of the property at 248.
Thank you.
So my comments revolve around the clarity and overall intent of the modifications and expansion of the property as shown on the use permit request and the associated drawings submitted herein at 248 North Bryan Street. I have 3 comments that I want to elaborate on. These pertain to the ambiguities and future intended purposes of the proposed rehabilitation expansion of the work proposed by the owner. The first is the basement level. So per the submitted documents, the basement level shows to have one large open area, and at the rear where there is the expansion, a yoga room. The current layout of the basement includes a couple bedrooms, a bathroom, a full kitchen, laundry area, dining room, and it's used as a Airbnb. However, the drawings that were submitted do not have any notations regarding any demolition or any notes that those existing facilities, that infrastructure, the walls, the piping, the plumbing and so on will be demolished or retained. The second comment revolves around the first floor. This is the existing first floor, where there is an expansion to the left and an expansion to the rear. It includes a couple bedrooms, a yoga room, and then one very large studio area. The first floor consists of the existing kitchen area, dining room, laundry, bathroom, and dining room area. Again, however, there's no notes on the drawings or what noting that kitchen area will be demolished and all the associated infrastructure removed. Thirdly is the new second level, which will be built, is being proposed to be built on top of the existing structure with an expansion to the left and expansion to the rear. This floor contains a couple bedrooms, bathroom, laundry area, full kitchen, dining room, living area. It's that with the kitchen proposed at that top level, it just appears that it's not consistent with the neighborhood in terms of the other structures that are built, within a block or two from that house. All of the homes that I'm aware of, whether they're existing original homes or a lot of new homes, do not have kitchens on their top level. So I find this to be inconsistent with the neighborhood and the feel of the neighborhood. So in conclusion, as the owner advances their design and gets more clarity on what they're proposing here in terms of what's going to be built, I would urge the county to compare those drawings with what the as constructed conditions will ultimately be. Thank you.
Thank you. Do my colleagues have questions for this speaker? Is Miss Gangemi? I'm sorry, one more time? Gangemi.
So good evening. My name is Stephen Gangemi. I live next door to 248 North Bryant. We're located at 252 North Bryant, one of the properties you asked about. Thank you for the opportunity to speak tonight. So first, as a preliminary matter, for all intents and purposes, this likely could have been a variance request, which is a much tougher standard as this board knows, but it was submitted as a use permit application. If it were a variance, as you know, the applicant must show a hardship due to this particular circumstance to the lot, typically relating to a condition on the property. There are none. It's a square lot. There's no topographical features, no unique trees, nothing which would require a variance request on this. The applicant must show that zoning ordinance somehow unreasonably restricts their utilization of the property. It doesn't. More than reasonable use, existing dwellings and improved ADU are already on the property. Any hardship that the owner faces is self-created. Personal preferences, lifestyle needs, design choices don't qualify. Ironically, the applicant chose the easier path of the use permit. He still doesn't qualify for the relief requested. So shifting to the relief requested, I want to emphasize that this application does not meet the basic requirements for setback. The zoning ordinance, as you all know, allows one side yard to be reduced to 8 feet or less only if the other side is at least 10 feet. As discussed, that's not the case here. So neither side is eligible for the reduction. This should be a bright line rule, and the proposal simply doesn't comply. Second, the property already contains a newly built accessory dwelling unit, which is still in construction, so I don't know how we want to refer to it. But with 2 dwellings on a lot, the owners already enjoy more than a reasonable use. Any claimed hardship that they have, again, is self-inflicted and self-created. The zoning ordinance is intended to help alleviate hardships tied to the land, not personal preferences or yoga spaces or playrooms. Third, if you look at the staff's own analysis, the proposed footprint is larger than nearly every home nearby. And the only larger example is more than 500 feet away and fully complies with the setbacks. Staff also found no comparable homes in the area, none that have received BZA relief for setbacks. The only homes with similar setbacks or variances were 60 to 100 years ago, long before this zoning ordinance was in place. This proposal would create a new nonconformity, not continue an existing one. Fourth, approving this setback sets a precedence for new construction to push right up against property lines on the small R5 lots. Our neighborhood depends on consistent spacing between homes and properties to provide privacy, light, and air flow. Once one oversized addition is approved with reduced setbacks, it becomes much harder to deviate from that precedent. Finally, I appreciate that the staff provided an alternative approval resolution, but it contradicts their own initial findings without any factual basis or supporting rationale. The staff concluded that the proposal is not compatible with the surrounding development. That should be the end of the analysis. A project that is not compatible with the neighborhood should not be approved. In conclusion, the applicant already enjoys more than reasonable use of the lot while conforming with the ordinance. There is no reason to grant relief. For these reasons, I respectfully ask you to adopt the staff's recommendation and deny the request as submitted. The only other thing that I would mention is just for the record, there are multiple letters in opposition in the supplemental records in case the board hasn't seen them.
Yeah, we all have them, and I can't say that everyone's read them. I have.
Okay, super.
Right. Staff provides them to us prior to the hearing.
Super. I wasn't sure based on the question. Apologies.
Thank you. No worries. Ms. Simkovich. I'm sorry. Did my colleagues have any questions for that speaker? I'm sorry. Yeah, well, we'll circle back. Sorry, come on, Del. Ms. Klein will not forget.
Hello, thank you for having me this evening. I'm Dr. Suzanne Simkovich. I live in 252 North Bryan Street, right next door. My husband just spoke. This is important as we chose to live in this community in an R5 neighborhood, as I work at Georgetown University Hospital and take call there and have to be there within 10 minutes if called into the hospital, which is why we chose this community. When we first walked into the community, we were living in a single family home community. Immediately after the applicants opened an Airbnb in the basement, which has resulted in a number of increased cars in our community, people hanging around on our front yard, food being delivered in the middle of the night, which I recognize Arlington does. But what is concerning here is since then, there has been an ADU started, which we were told was going to be a small property. This is 1,300 square feet, and I have brought pictures of what is currently being constructed in the backyard, if is okay if I provide you
Mr.
with the
Goldberg.
pictures. We're here in opposition tonight as the plans as submitted give the impression that they are attempting to build multifamily home and housing, as it seems very unusual that there is a kitchen on the second floor of the proposed design, in addition to there being this large ADU that is coming up next door, and they are already running an Airbnb in the basement, which the permit is questionable and under investigation as it's not recorded in the available documents by the county. So that we ask respectfully also that in my conversations with the applicant, that they have told us they're looking at multifamily housing, and that if we don't like it, we should move to McLean. So it has brought some concerns of the intent of this actual property that I hope that the board can consider. Thank you very much.
Thank you. Any questions for that speaker? And the last speaker, Mr. James. Ms. Klein, quick question. I assume, just confirm that the footprint in the staff report includes the under construction aspect of this property?
That is correct. Yes.
Thank you. Please go ahead.
Thank you for allowing us to speak, and I will keep my comments very brief. So I am
Name
Ethan
and
James. Pardon me?
Name and address.
Yes, I'm Ethan James. I live at 244 North Bryan. That's the house adjacent to his, directly to the south. So Suzanne and Gregory, or excuse me, Suzanne and Stephen are on the other side. I'm on the other side of that house. So I just have real three concerns. I agree with everything that Sean, Stephen, and Suzanne said. And I signed one of the letters that you had before you. And so I won't get into the technical aspects, especially since they're eminently more qualified than I am, especially Sean, who is a former building engineer for all the national monuments. So my concerns are really three things, and these are kind of broad concerns, but you know, as you said, you guys are a safety valve, and I really appreciate that. And I appreciate the rigor through which you apply the regulations to building construction in Arlington. So our first concern is that, yes, as has been mentioned, there wasn't a lot of communication with us. Brian did communicate to us 2 days ago or 3 days ago via an email what he had planned, but I was still very unclear. And when I first saw this hearing was going to take place, I assumed it was for the ADU that was being constructed in the backyard. The first news that we heard of that is when they broke ground with heavy machinery. There was no plans posted, and we didn't even realize that that was happening until there's a giant footprint of a basement. The second thing, so that's concern one. The second thing is that, like Suzanne mentioned, and Stephen and Sean was mentioning, that we're concerned about unapproved commercial use of the property. And so he has an ADU in the basement, totally fine with that. I mean, there are other concerns with that, but I think that's his right to do that. And, you know, in these tough times, you know, folks got to make a buck, and I totally understand that. But with the prospect of people potentially in the house and the ADU, that's a lot more traffic. And the enforcement of that will fall to us. And we don't want to have to be playing the bad guy and kind of, policing any extra ADU stuff. And the third thing is future concerns is that if they decide to move and sell this property, then whoever comes next, the potential to have multifamily dwellings on the same property, that does affect our lifestyle and our property. So those are my real three concerns, in addition to everything that Sean, Stephen, and Suzanne said. So thank you for your time.
Thank you. Any questions for this speaker? Thank you.
Cheers.
I think it's only fair to let the applicant have a very brief period to speak about the neighbor outreach, the neighbor feedback that we just heard. And then I will entertain any additional questions for the applicant.
Thank you, sir.
Or staff. Thank you.
Okay,
Go ahead.
so this is the situation. They're here not because of this addition. They're here because of we had a disagreement both on both sides on the fencing issue. So on the left side with the fencing issue, I have an email from the neighbor on the left side because they want to remove the metal fence, but the metal fence is actually 6 inches on our property. So we have email back and forth that said the metal fence is on our property because when we bought the house, we had a survey and it shows it's on our property. And he sent the email says, yes, we got a survey done too, and it shows it's mostly on your property. So you can keep it or remove it. We will build a fence on our side. So that's what they did. That was like years ago. And then our new neighbor moves in and they wants to build a fence and they want us to remove the metal fence on their side. So we said, oh, we have a survey and it shows that it's a common fence. And they got a survey done. It also shows it's a common fence, but
Boundary fence.
but they threatened us to remove it because they say,
Yeah, I'm not.
I'm a lawyer and I'm going to sue you and I'm
yeah,
going to
I
do it
mean,
anyway. Yeah.
I think we're more interested in the actual comments that they made.
So
Not we're not going to get into the history of neighbor. We understand that neighbor dynamics are difficult.
They are here because they want to make it difficult for us, and that's what they said before. And I can show you all the survey and stuff
So
if it's necessary.
So Mr. Gangemi told us point blank on his front lawn 2 weeks ago that he intends to block everything that we intend to do. He reminded us that he's a lawyer and he will block everything and bury us in litigation.
Okay, thank you.
There's a lot of personal
They-
animus.
We get it.
between
Thank you.
us.
Yeah.
Yeah.
So about the parking thing is because we have construction right now. Oh, the one thing they said, we don't have a permit on the back. We do have. And they did call the county and county did come, says, do you have the permit? We said, we have all the permit and the county says that everything is fine. And then they left. And then they have problem with the workers parking on the street.
Okay, I think
Yeah.
I think we understand. We understand that there's a lot of neighbor issues going
Yeah.
on.
Sure.
So,
So do my colleagues have any questions for this applicant?
I'd like someone to address the multiple kitchen issue.
oh, the kitchen, because I'm a jeweler, I work at home, so I need a area with sink stuff. So since we're having the second floor built, we pulled the permit of a business, a home studio. So we thought, okay, well, right now the kitchen is very small. So we'll just abandon that kitchen and we have a nice kitchen upstairs and I'll use the downstairs as the jewelry studio for the, the sink area. So that was the arrangement. That's why on the drawing it shows studio.
And for the record, it's our neighbors speculate that we're going to build multifamily dwelling. We have 2 children and we have a mother-in-law.
Yeah, you
and
don't have to say that.
We have no intention of building multifamily dwellings. We just want to enjoy our property and have the same rights and privileges to build as they have built
They
on
have
their
a big
property.
house and they don't want us.
So I don't know why we are being excluded from our rights and privileges to build within reasonable limitations.
Thank you.
Thank you, sir.
Ms. Klein.
Your question regarding
question.
the buildings. Our records indicate that both 244 North Bryan Street and 252 North Bryan Street have not received variances to construct their homes
Use permits.
or use permits. I will note that there was a variance issued for 244 North Bryan Street in 1998 for 15-foot separation between the main building and the accessory structure. However, that original structure actually has a original construction date of 1930. The other building has a construction timestamp date of 2023, but there are no variances or use permits on record for that building.
Thank you. Discussion with the board.
I think,
Come on up.
thank
Lead
you,
us
Chair.
off.
Yeah, I think stating the obvious, this seems like a personal issue in the neighborhood. And I think probably far more than just the 2 inches that we're talking about here. Because just to confirm, if I could just
Please.
make some statements.
Go
like
ahead.
The newbie here, and just correct me if I'm wrong this is before us over 2 inches, correct, Ms. Klein?
On
Or, in a sense.
sure,
Like there's a reasonable path to doing this by right.
correct.
So having said that, with assuming they went back and did that, the Airbnb would still be there because we can't decide on that and we kind of pine on that. The multiple kitchens can be there because we can't opine on that nor make a ruling on that. The parking, the folks coming at night, all things that we can't opine on or make a ruling on that would still be there if this was modified ever in the slightest. Same with the yoga studio, same with multiple generations of families living here. Personally, like, there's just comments and then terms used that make me a little uncomfortable at how personal this has gotten. But I just want to, before we talk about the merits, I want to narrow the scope down about what we're talking about here, which is the setbacks and how big those setbacks are that we're debating here, and not who lives in this house, what they build in this house, what activities they like to do in this house, and what kind of businesses they run out of the house. Those are things that are either legal that we get to enjoy here, or if they're not, they need to be addressed in another venue other than this one. I think are those fair terms that I've kind of run through in my head? Am I wrong about anything, I guess, to you all?
Ms. Malice.
I agree with what Mr. Kamana said. We can't, there may or may not be code enforcement issues. We can't address that. We don't address the use per se. We are strictly looking at, in this case, the placement of the building. And I think that's where our focus is going to be. I personally don't see a compelling reason to approve this use permit, partly because the proposal seeks to build pretty much the maximum that's allowed. And so I'm not sure that I would support any additional, let's say, discretionary relief. They can build by right, but right now they're maxing out pretty much lot coverage and they're getting close to footprint. So I don't see why the plan simply can't be adjusted to make this by right.
Thank you, Ms. Malice.
Mr. Chairman,
Ms.
I would agree with Ms. Malice, and just looking at the difference in what they want to do on the left side, it appears that the existing structure is okay. And so adding a couple of feet that brings us all into this whole new realm is, I would say that they can modify the plan if they want to in order to build by right. And it's still going to be a whole lot of building on a very small lot. But if it meets the criteria, for setbacks, then so be it. But I don't feel comfortable making that adjustment, even though you can say, well, it's just a couple of feet. Well, yeah, most of what we deal with is a couple of feet. So that is not at all persuasive.
Thank you, Ms. Freshman. I see no other hands. So I like to bring us back to the standards of what use permits are. And the county board has given us direction that the applicant has the burden of proof by a preponderance of the evidence to establish the compatibility of their project with the surrounding neighborhood. Here, and I don't want to minimize the neighbor comments, but here, a lot of the neighbor opposition is based on the actual use of the property, which I typically don't see that as something within our purview to review, because we're a zoning board and we're more concerned with the placement, as we've been talking about ad nauseum tonight. So what is before us is whether this project meets the compatibility of the neighborhood. And I do not believe that this applicant has met that burden. Typically, when staff gives a recommendation of denial, it provides a higher burden on the applicant to present to us compatibility with the neighborhood. That's just kind of the nature of recommendation of denial versus approval. Because if there's an approval, staff does the work for that burden. And in this case, this project is 20% bigger than the neighboring property by 400 square feet in terms of footprint. And no one has provided any comparable for the size or scope of the setback relief. So although the setback ask is relatively small, the applicant has not provided us any comparables or evidence that compatibility has been met by such a long two-story full wall setback relief on that left side. And so that's my reasoning. So if no one else has anything else to add to that, would someone like to make a motion?
Just one last.
Mr. Kumana.
I think I agree with you all as is. I just wanted to be clear. I wanted to agree with you because of those things, right? That's kind of what I was getting at. Like, these are the merits on the case. And Ms. Freshman, I wasn't diminishing the requirements or anything like that. It's just, this will probably get built one way or the other,
Right.
by right or by how it's now, right? It's so close to the finish line.
And I think that's a great point for the neighbors is, that there is likely to be built a second story addition, which could probably be built by right, but I won't speak. We are not county staff. We don't work for county staff and we don't issue approvals in that manner. But I am assuming that there are projects here that can be built by right pretty substantially, if not more substantially than the project that is before us tonight. Would someone like to make a motion?
Mr. Chairman,
Ms. Malice.
I move that the Board of Zoning Appeals adopt the attached proposed resolution denying the use permit V-12096-26-UP-1.
Second.
A motion for denial as advertised by Ms. Malice, seconded by Ms. Freshman. Is there any further discussion? Discussion amongst the board. The public comment period has been closed. I just want to add that I hope that all of the neighbors can come together with this afterwards, because we hear a lot of these type disputes, and it's always unfortunate what can be a result of a project on both sides. So hearing no more further discussion, I will call the roll. Ms. Malice?
Aye.
Ms. Freshman?
Aye.
Ms. McCoskey?
Aye.
Mr. Kumana?
Aye.
Chair votes aye. Motion for denial passes 5-0. I know it's unfortunately not the result you want, but you do have other options to pursue your intended project.
To staff.
Just you can follow up with staff on how to proceed next. And thanks for all, civic participation is always great. So thanks for participating.
Of the board? Oh.
And she's got to call the next case.
No. We're bulletproof.
I know.
Thank you.
Thank you, Ms. Klein. Can you call the next case?
Yes. Case number V-12097-25-UP-1, a use permit request by Matthew Spina of Caribbean Pool Service, Inc. on behalf of Edward and Lisa Dahl, the owners, to permit a rear setback of 7.3 feet to the accessory structure, an above-grade spa/hot tub, instead of 25 feet to the spa as required, regarding a new in-ground pool with an above-grade spa and porch column addition to an existing one-family detached dwelling in the R10 zoning district on the premises known as 6619 31st Street North, Arlington, East Falls Church. And staff recommends that the board adopt the proposed attached resolution denying the use permit request. An alternative resolution with conditions has been provided should the BZA see fit to approve the use permit request as advertised. And please note there is supplemental material for this case that came in after the application packet was assembled and printed, and that includes 5 signatures of support.
Thank you, Ms. Klein. Do my colleagues have questions for staff on this item? Sorry. Ms. McGoskry, thank you. I need a red blinking light. Go ahead.
It's fine. I'll interrupt as I've
Yes,
shown.
please.
But so as I tried to determine this, which is sometimes not the right way, it seems like because a garage is an accessory building, it could be built in this location as long as it's not over 1.5 stories or a certain number of square feet. But this pool wall cannot, because it is not an accessory building, it's just a structure. Is that how this kind of turns on whether they can do it or not under the ordinance?
That is correct, essentially because there is not an explicit exception to the setback requirements for this type of structure. It must adhere to the typical rear setback requirements, or all the setback requirements.
Thank you.
Thank you. Anything else? Anything further? I guess just a rhetorical question for I guess everyone here is, for the compatibility standard, are we just looking at setbacks, or are we looking at what the structure is, right? Because oftentimes we look at what the structure is, and in that case, there's not a spa or a pool, that would meet this. And so that's what I'm kind of grappling with. I assume the applicant is online because we're speaking to an empty room?
Yes, I'm here.
Would you like to speak? I assume you would like to speak to your application.
Yes, please. My name is Matthew Spina. First, I apologize. The video is not working. I tried to get it to work on the app, the Teams app, and then I couldn't see any of you. And then when I have it on the web browser, my video won't work.
That is okay.
But I assume everybody can still hear me.
We can.
I think I will first address the question that was just proposed. So for clarification, it is correct that the garages can be built there. What I want to make sure to make the point to clarify is there is nothing stopping from the pool itself or the spa itself being built there. What's in question here is that the client can build this structure up to 8 inches above grade. What we're asking is that we go to 18 inches above grade. So that extra 10 inches is what actually now makes it where it needs this use permit. For instance, if the use permit was denied, the spa could be built on grade right where it's proposed, and it would be completely conforming and nothing would stop it. So just from a standpoint of use itself, the spa is less detrimental to any neighbors than a garage would be, which would block light, block wind, block views. Whereas this spa structure doesn't do any of that, especially only being 18 inches out of the ground. And again, I'd like to point that if it was 8 inches out of the ground, it's completely conforming and allowed to be there. So that 10 inches really doesn't make any bit of a difference for neighbors, for use, for noise, for really anything that would affect anything at all. In fact, not allowing it to be the 18 inches out of the ground makes for, and I put this in the letter, it makes for a less safe environment for the homeowner's children. You now have a spa that's on the upper level, where if parents or anybody is on the lower level and a child was to then fall into that, because there is nothing like an 18-inch height to block somebody from falling in there, you now have a less safe structure up there, all for a difference of 10 inches.
But how is that a
I would
safety
also,
issue if the pool is at ground level, so anyone can fall into the pool? So I'm
yes,
having
but
trouble seeing why that's
so
a
the-
safety issue. And,
so
and
the
I'm not even
difference
sure that a
is,
safety issue is a standard that's before us.
well, so the difference, no, it's not. I'm just trying to explain to you the reasoning behind why the 18 inches is proposed versus an on grade. It is at a completely different level. It is up a set of stairs up to that level. Keep in mind that this existing backyard is severely sloped as is, and the neighbor behind is already above grade from the client's house.
I guess my question is, if that spa is not at the same level as the pool, how is that an additional safety hazard that isn't similarly situated to the pool?
Because it's up a set of stairs, similar to if your child was upstairs in your house.
No, right. I
versus-
that's not the question I asked. If the pool is at the same level if the spa is at the same level as the pool, how is that an additional safety issue, right? You can build the spa at the same level as the pool by right. So why are you before us asking for an exception to the zoning rules as a premise of being a safety issue?
Well, a spa has a bench in it, which when a child falls in there can hit the bench. A spa has the steps in it, and a spa is not at the same level as where the parents are down at the lower level. However,
the pool has no steps?
The pool has steps. It is where parents are. Now, I think we're getting off track.
Okay.
Let me bring you back on to, as I stated, I'm giving you all of the information for why this spa is where it is. I think you're focusing on the safety issue, which is, yes, an issue, but just one of many in this case. But let me bring you back to the point that, again, the spa where it's proposed can be exactly where it is. We're talking about a difference of 10 inches where, again, let me go back to the neighbors. Every neighbor surrounding has approved it. I know in your previous cases, you had some neighbor, opposition. There's no opposition in this case. As the staff reported in their findings, there are multiple neighboring properties that have accessory structures built that are less than the 7'3" we're asking. They're actually 2'1", or in one case, 0 feet. I'd also like to point out that the BZA already approved in June of 2023 at 4425 33rd Road North, case number V-11832-23-UP-1, already approved for an above ground pool in a very similar situation. We're asking for a spa, smaller structure, again, can be built exactly where it is. We're asking for a difference of 10 inches. I know as mentioned in previous cases, everything that you guys are reviewing comes down to feet and inches. But again, I'd like to point out that in this case, it's a very small amount, and it provides extra safety. It provides with the upper property that runs off down to the lower property, any rainstorm with something that's on grade like that, all that runoff goes directly into that spa. That causes a hardship on my client, that then that spa is now stained and has many issues with any rain runoff, mud staining the plaster, all of those types of things. Let's see. Sorry, let me go through my notes here. Let's see. I covered that. Covered the water runoff.
Do my colleagues have any questions for this applicant? Ms. Mallon?
Page 14 of the staff report, there's a picture, and I'm looking at the top picture. And I wonder if, does the applicant have access to this, to the staff report and can look at the same
Yes.
picture?
Yes.
Page 14,
Yep.
the top image.
Yes.
Okay. The wall that we're talking about is the wall that's parallel to the pool coming up the steps, as well as surrounding the hot tub?
Yes. Both of those walls are 18 inches above the deck grade, which that grade at the top of that yard, as you can kind of see from this image, that grade at the top of that yard is already above what the pool grade, everything else
Right.
is. It's a hill that is in the yard currently.
So there's a, so the,
So that spa itself and that wall can be built exactly where they are. They just, what we're asking for is, if I built those, let's say this image was showing those only 8 inches
Mhm.
above, they would be
Mhm.
perfectly allowed.
they
But
would be
8
perfect, wait a
inches
minute,
would
whoops,
be
perfectly level with what?
Allowed, not level.
allowed.
Oh, allowed.
It would be
Right.
compliant. Compliant. Sorry, I'll use a better term. It would be
I'm sorry.
perfectly
No,
compliant.
I misheard.
But obviously 8 inches you wouldn't do. You'd do either on grade or 18. But for the purposes of what's allowable and compliant, it could be 8 inches. So what
And-
we're actually requesting is only 10 extra inches.
And you wouldn't do 8 inches because it's more like a tripping hazard?
Yeah, 8 inches would be more of a hazard, a safety hazard, than putting it on grade. Because obviously 8 inches is just, you're not stepping up, you're more tripping than anything else. In that case, you would just go with on grade.
And then on grade would mean that that deck around the hot tub would just, it'd be like
Go right into the
like
hot
a
tub.
diving board into the pool.
Well, yeah, like a ledge that you just walked off of and then fell in.
Yeah, there would be no,
Like a
no
normal.
protection there at all.
Correct. Yes. And
And
the
what,
neighbor.
is that the deep end of the pool or the shallow end?
So
middle?
in this case, this is actually a sport pool, so it's deepest in the middle, and shallow on both sides.
And so,
Shallower on both sides.
and what's the depth of the pool right there?
It's 5'5", or sorry, 5'6", 5.5 feet in the middle.
So you're trying to prevent someone from just walking into the pool and walking and falling
From
into
the
pool.
upper level, which is obviously more dangerous because it's a further distance that you're falling from
Right.
that upper level down to the lower level. Similar to why you would have a railing on a deck. If a deck
Right.
was 6 feet up high, you'd have a railing on it, just like is required in any retaining walls above certain height. You have to have a railing.
Thank you. That's very helpful.
I get the safety issue now. Right. So it's not that it wouldn't be built at this because the ground is higher there.
Right.
Correct. Yeah. So
Right.
it's not.
I was missing that.
Okay. Yeah. And again, it's also, that runoff from behind the white fence in the picture you're looking at, that's the neighbor's property, which is significantly above grade and keeps sloping up to that neighbor's property. So my client's property is the downhill result of any rainstorms above.
Yeah.
Anything further for this applicant?
Um,
Alice?
Just a comment. I thought your report was very well done in terms of laying out the issue. My only quarrel with it was that you sort of minimize things by saying that the ask is 10 inches when the ask is really multiple feet. Because that's what the setback would have to be, and you don't have to argue.
Oh,
or
yeah.
address
Okay.
that.
I understand what you're saying. You're saying the 25 feet versus
Right.
Yeah,
versus,
yeah.
you know, you sort of minimize, you're saying you're asking for 10 inches and you're really asking for 20 some feet.
Yeah.
But I understand what's happening here. I appreciate it.
Yep.
Thank you. Discussion or motion?
Mr. Chairman,
Ms. Malice?
I'm inclined to actually support this request. But I don't know where my colleagues are on this. So if there's others that have comments they want to make first before we do a motion.
Ms. McCoskey, I see a hand.
Yes, I agree with Miss Malice because I think, aside from all the safety issues and all, I have a hard time denying this based on compatibility with the neighborhood when a garage could be built there by right. It seems to me that objecting to this 10-foot or 10-inch wall, you know, when you could put a garage there with maybe 6 or 8 foot walls, that doesn't make any sense to me in terms of being incompatible.
Thank you. I'm gonna switch roles with Ms. McCoskey, who typically takes the argument of contrary to the county board policies and master plan, which is an interesting side note. But I think that this is purely, and I suspect this will pass anyway, and that's great for the applicant. But I think that this is purely design. There are other designs here that could be both safe and within the planning. I also have trouble with the compatibility because there are no comparables to it, right? And so by definition, is that comparable? And so then that's a debate between setback to a building or garage versus setback to a pool. And we regularly take that into account in our other cases. And so I wanted to jump in there before, if there was possibility of a tie vote, so that I don't have to be the tiebreaker.
Is it okay if I would just like to point out that as far as the comparability, I did point out that one case in June of 2023 that while it's not in this neighborhood, it's
it's not really a comparable for the neighborhood because that's what the county board states is. But a use permit is also unique to the property, and so I personally can't take that into consideration because I haven't had time to review the actual unique aspects of that particular item. But so
Thank
we're
you
gonna
for the explanation.
We're gonna discussion is going to be with the board. So,
Mr. Chairman,
Ms. Fresman, please.
I could go either way, actually, but I think that they need to really take into consideration the runoff from the property behind, which I think is more of a negative than a few inches either way.
Would someone like to make that motion?
Mr. Chairman,
Ms. Malice?
I move that the Board of Zoning Appeals adopt the alternate resolution approving use permit V-12097-25-UP-1 with conditions.
Second.
A motion by Ms. Freshman for the alternate approval with conditions made by Ms. Malice, seconded by Ms. Freshman. Is there any further discussion? Hearing none, I will call the roll. Ms. Malice?
Aye.
Ms. Freshman?
Aye.
Ms. McCoskey?
Aye.
Mr. Kumana?
Aye.
Not determinative. Chair votes no. Motion for this project passes 4-1. Good luck with your spa pool project. Looks pretty cool.
Thank you.
I believe we have minutes to pass.
I move approval of the minutes from the February 18, 2026 BZA hearing.
Second.
A motion for passage of the minutes by Ms. Freshman, seconded by Ms. Malice. Hearing no further discussion. Ms. Malice?
Aye.
Ms. Freshman?
Aye.
Ms. McCoskey?
Aye.
Mr. Kumana?
Aye.
Chair votes aye. Motion for minutes passes 5-0. And I don't believe we have any further business to address. So the agenda having been complete, this meeting is hereby adjourned. Have a good